All right, we are live.
All right, good morning, everyone. Welcome back to House Government Operations and Military Affairs. It is Wednesday, February 11th, just after 9 a.m. Our first order of business today is with the Human Rights Commission. We're joined by Big Hartman, Executive Director and General Counsel for the Vermont Human Rights Commission. And today's Disability Advocacy Day. And have we seen any of this yet?
I've never been in this committee.
You've been in this committee when we were down in room 10. I don't feel like we've seen each other.
We pass each other all the time, but I don't think I've testified here before.
Really?
Yeah,
Wow.
must have been four.
Before, perhaps? In like one of my previous committee incarnations? Yeah. All right, well, anyway, welcome. Here we are. You found us. So, yeah, table is yours.
Okay, well, hello, everyone. It's very nice to meet you all today. My name is Big Hartman. I use they, them pronouns. I'm the Executive Director and General Counsel at the State of Vermont Human Rights Commission. I was very honored to be invited by the Vermont Coalition for Disability Rights to speak with you today on Disability Advocacy Day. So I'm going to go ahead and share my screen as we'll go through some slides. Beautiful. Technology is cooperating. That's a good sign. Yeah, so just by way of introduction, I have been an attorney here in Vermont for 20 plus years now. And I joined the Human Rights Commission as a staff attorney investigator in 2021, and I became executive director in 2023. So today I thought I would give you an overview of what disability discrimination laws we have in the state, what our office does to enforce those laws, some stats on our recent disability-related cases, and some recommendations from the 2025 Civil Rights Summit that the Human Rights Commission put on in November. So the Human Rights Commission is an independent commission of state government. We have 9 state employees. Our mission is to advance full civil and human rights for Vermonters. We are seeking to protect people primarily from discrimination. We investigate complaints. We help trying to resolve complaints. We file lawsuits, and we do what we can with our limited resources to educate the public for prevention of discrimination. We have 3 main buckets of jurisdiction when we're talking about anti-discrimination laws in Vermont. So we have our fair housing protections that prohibit discrimination based on legally protected categories in housing, places of public accommodation, and employment. So the Human Rights Commission doesn't have, we have limited jurisdiction when it comes to employment discrimination. As you probably know, the Attorney General's Office Civil Rights Unit processes complaints of private employers and any non-state of Vermont entity. But for state of Vermont employees who feel they've been discriminated against, they file their complaints with us. Other than that, we are the sole enforcement authority for fair housing and public accommodations. Just a quick overview of the HRC complaint process. And I'd love to come back to the committee another time and give you a broader conversation about what other work we do and our non-disability related cases. I did mean to bring my hard copies of my annual report and our summit report with me today, but those are in the back of my car, buried in the snow, far away. So I'll potentially drop them off later today. So HRC receives complaints on a daily basis, or rather requests for complaints. We have a pretty extensive intake process because we do not have the resources to accept all the complaints that Vermonters would like to file with us. So we do vet complaints before we accept them. And that's with our full-time intake coordinator, a new position that was actually created just this fiscal year. Then we have staff attorney investigators. This year we have 4 full-time investigators who are conducting all of the discrimination complaint investigations throughout the state. They conduct pretty extensive investigations, interviewing witnesses under oath, document reviews, and then they write an investigative report that summarizes why they believe that there are grounds or no reasonable grounds to believe that discrimination occurred. Those reports are reviewed by 5 commissioners who are appointed by the governor and meet once a month. Our chair is Kevin Coach Christie, and they will make the final determination about whether or not there's reasonable grounds to believe that discrimination occurred. If they find that there's no discrimination in a case, that's the end of the matter, and our work on that matter is concluded. The entire existence of the complaint is confidential by law. However, if we find reasonable grounds to believe that discrimination occurred, that determination is a matter of public record, and we are still involved with the case. We have a 6-month period in which we're trying to work as a party to the case at that point to try to resolve the matter. And if we're not able to do that, we do have the authority to enforce violations of our anti-discrimination protections in court by filing lawsuits, where the Human Rights Commission is the plaintiff. And up till that point in time, I just want to highlight that we are impartial investigators. We are not representing complainants or respondents in these cases. We are really a neutral fact finder. As we speak today, the Human Rights Commission has 14 cases that are actively being litigated. So I'll turn over to disability rights. We're going to cover housing first. Basically, people with disabilities have rights to apply for housing and be offered housing on the same basis as tenants who do not have disabilities. They have the right to be free of harassment based on their disability, discriminatory statements, and any other discriminatory treatment in housing because of their disabilities. And many of our cases involving folks with disabilities involve requests for reasonable accommodations. They also have a right to modifications in housing. We typically will defer to HUD guidance in how to interpret our statute because our state law is comparable to federal fair housing law. However, I will say, as of lately, HUD has started to pull back a lot of its previous guidance. They are withholding funding as we speak today for a cooperating agreement that we have with them to do fair housing work in the state. And in general, we are feeling that fair housing is being effectively dismantled on the federal level, leaving the burden on us state agencies across the country to fill that void. Just a little bit of a definition here, because so many of our housing cases involve reasonable accommodations. I thought I'd share with you that that is defined as any change to a rule, practice, or service that is needed to give a person with a disability an equal opportunity to use or enjoy a dwelling. So this is where we're talking about changes to how a housing provider does things typically. So some examples of common reasonable accommodation requests in housing might be a request to have an assigned accessible parking spot, a request to be able to have a service dog in a building that has a no dogs policy, maybe a waiver of a pet fee for an emotional support animal, or for folks with different communication barriers, they may ask that the landlord communicate with them in writing instead of verbal. Just a few examples to illustrate what that looks like. We also less often find cases involving reasonable modifications. This is where there's a need for some kind of structural or physical change to a physical space in order to ensure that someone with a disability can use and access their dwelling. This can be things like grab bars in the shower, a fence in the yard for a service dog, maybe a wheelchair ramp, or for a person with hearing loss, they may need like a light strobe for their fire alarm. Just a few illustrations of that. So of course, housing providers don't have to grant all reasonable accommodation or modification requests. The law does provide some defenses or legal basis to deny those requests. First, if there's no connection between the disability and the requested accommodation, you don't need to grant it. If granting the request would impose an undue burden on the housing provider, they don't need to grant it. Or if granting the request would fundamentally change their services or their business. But we do expect housing providers who are even contemplating denying a request, that they're going to engage in an interactive process with the person who's making a request to see if there's some other way that they can meet that person's disability-related need without having such a burden on their operations. We do see housing providers sometimes skip that step, just give an outright denial. And often we're needing to educate housing providers about this obligation. So I'm flying through this. Let me know if you have any questions along the way. Just wanted to give you like a primer of our anti-discrimination protections. We also, moving on from housing, we have protections in places of public accommodation. This is going to include, so place of public accommodation is extremely broad under state law, and we do not have a federal law counterpart to this. This is purely state law anti-discrimination work. And a place of public accommodation is basically any place that serves the public. We're talking about schools, businesses, hotels, restaurants, any kind of government office. All of this is going to be considered a place of public accommodation, and people have a right to be free of discrimination in those places. Here's a list of your legally protected categories in public accommodations, but disability is by far the most represented type of claim that we see. I will note, I just noticed this is a slide that I used from last year. Since this law was passed, we now have 2 new legally protected categories. Does anybody know what they are? You passed it last year. Immigration status and citizenship are legally protected categories now in Vermont, helping make our state one of the most expansive anti-discrimination laws in the country. In general,
Answered my first question. Like, how do we match up nationally? So thank you.
yeah, we're doing pretty well. There are some jurisdictions that have a few more additional legally protected categories, and there are certainly states that do a better job of education and enforcement. And it's really about resources for our office to be able to do that. But in general, in any place of public accommodation, no one can be denied or refused the services of a place of public accommodation because of their membership in a protected category. So when we talk about disability discrimination in places of public accommodation, like I said, we're often talking about some type of denial of an equal opportunity to use or access that place. The law provides, so this is like our state version of the ADA when we're talking about the disability rights. In general, the ADA and our state law requires that accommodations and services should be offered in the most integrated setting appropriate for the needs of the individual, and that a public accommodation needs to take some steps to ensure that folks have access to their programs and services. So these laws were not on the books until 1991, and they only became laws because the disability community fought extremely hard over decades of advocacy and organizing and political pressure to ensure that first a federal law was passed, and then we could have some state level protections following from that across the country. They use the concept of reasonable modifications in the context of places of public accommodation. It's very similar to what we were talking about with reasonable accommodations earlier in housing, which is basically sometimes we're going to acknowledge that folks with disabilities may need changes in how things are done in order to ensure that they have the same access to the place of public accommodation as everyone else. We have those same 3 exceptions that we saw in housing that we have in places of public accommodation. And there's also a set of accessibility rules, accessibility statute requirements that ensure that public buildings as well as dwellings have are meeting the standards of accessibility. This is where we have things like requirements about accessible parking, ramps, features such as water fountains and signage being accessible for folks that use wheelchairs or have other mobility challenges. And then there's also a requirement that if your public accommodation space has architectural or communication barriers, that you will remove those if it's readily achievable to do so. And of course, attorneys will dispute all day whether or not something is readily achievable. These days, we don't see that many accessibility complaints. Most of them tend to be in the issue of either being treated differently because of a disability or being denied access, but not because of an accessibility issue. I have a slide about service animals because there is actually a growing body of cases we are processing right now and have been processing over the last few years where folks with service animals are being turned away from retail and restaurant establishments and hotels unlawfully. So people have a right to have service animals in public places. That is typically going to be a dog, although miniature horses are also qualifying as service animals. If you ever see a miniature horse service animal, you need to take a picture and send it to me because I really want to see this. They live longer, they're larger, they're house trainable. I don't know. It's really interesting to me. I want to see the horse. Okay. There's still a lot of education work to do for businesses, especially to understand that they have an obligation to ensure that folks who rely on service dogs have the ability to use and access their place of public accommodation. And there is a limited number of questions that are permissible under both federal and state law. And a lot of employees of places of public accommodation get no education and training on this until all of a sudden someone comes into their premises with a service dog and is often the person who needs to do the education and advocacy on the spot. I've worked with a lot of folks who have rely on service dogs to be able to access civil life. And my experience with those folks is that when they experience a denial or a refusal to be permitted access to a place, it has a very lasting, potentially traumatic effect on them. And when it happens again and again, and people question whether they need a service dog or whether they are disabled, it can really weigh heavily on folks and actually present a bar from them even feeling like they can go out in public.
Right. Okay. So, no, so this actually answers a longstanding question for me. So I'm a 30-year hospitality industry veteran. And so I've been in those dining room environments before. So if I heard you correctly, you said that only dogs and miniature horses qualify?
As service dogs, as service animals. Yes.
What about the emotional support definition or that application?
Great question. We are talking about this all the time in our office. We get questions from the public about that all the time as well. So the way I look at it is assistance animals is a broad category of animals that folks with disabilities need to ameliorate or support them with their disability. And under the broad umbrella of assistance animals, one type of assistance animal is a service dog, and another type of assistance animal may be an emotional support animal or some other assistance animal. In housing, folks have a right to assistance animals. Okay, so it's broader, right? Because we're talking about where you live. And your needs at home might be different than your needs when you're going out in the public. But when it comes to service dogs, so emotional support animals typically do not qualify as a service dog. However, there are folks who have like psychiatric disabilities that the dog may be trained to assist them in those situations and also qualify as a service animal.
Does that go Does that go beyond the dog and the miniature horse though?
Not for public places.
Okay.
Now, a place of public accommodation,
That's my question. Yeah.
No.
Okay.
The requirement, the bare minimum legal requirement is to ensure that folks with service animals can access that place.
Yes.
Places of public accommodation can do more than the bare minimum and allow other types of animals that provide emotional support if they choose.
Okay.
And we would see that as a more inclusive practice.
No, for sure. But also being someone who has like broad reach into the industry and the sector with the education is lacking. Like, I feel like I'm a good resource for those points of contact. And I'm going back more than 10 years now. And this was a real situation. And I'm not saying it as like a laugh track, but we had somebody in the dining room who had an emotional support ferret. And I was really wrestling with that concept on how to handle it because it was a difficult sort of difficulty with the table next to them with the presence of the animal. Even though it was like leashed, but it was very present on the person and very present on the table. So a situation like that, would that have been discretion of the proprietor as to whether or not allowed?
Yes, and I think there could be accommodations you could make, some modification to say, you know what, right in the middle of the dining room, this might be a little hard on folks. Would you mind, seeing if there's another location in this facility that might, be easier on folks? I don't think you have a legal obligation to allow that animal, especially if it's disrupting the situation.
It was a very unique scenario,
Yeah.
right? Like
Right.
that definitely has not happened since. But it just is the one that stood out in my mind because I really just didn't understand what the sort of like, what the parameters were for engagement, I guess is the best way to put it. So that actually clears a lot up for me. Thank you. So I'm going to Hango, then Hoover, Burlington.
Thank you. So the questions you had up a few minutes ago about the two questions, oh, they're right there.
Yep.
The two questions that are permitted, are those only for service animals? So how would you know the difference between a service animal and an emotional support animal that's on your premises and whether you're allowed to ask those questions?
So you're allowed to ask those questions no matter what. That's okay. Those are the legally permissible questions.
Okay.
Where we see people run afield of that is saying, why are you disabled? Show me your certification for this animal. I need a doctor's note. Those types of things for places of public accommodation are going too far. When we're talking about folks who need permission to have an assistance animal in their housing, you can, if you need to verify the need for the animal, you can ask for verification documentation.
Okay, but what work or task is the dog trained to perform is an acceptable question.
Absolutely.
In a restaurant.
Absolutely. Yeah, and you also don't have to ask those questions if it's,
The
yeah.
person has to answer them.
Yeah. And the folks that I've interacted with have those answers ready to go. And genuinely would not be able to go to a lot of public places if they didn't have the benefit of their animal.
I just wonder about an emotional support animal, like can everyone who has one really answer that second question?
They
Are they able to? I mean,
they often are prepared because they know that those are legally permissible questions.
for an emotional support animal, those seem like that second question seems very specific to me. So,
I will say not all emotional support animals are actually trained
yeah,
to provide emotional support.
right.
A lot of cats, for example, provide emotional support at people's homes, but it's very hard to train a cat to do things. I mean, depending on the cat. But, so there is a distinction there that there may be, what I've seen is folks who have service dogs who can sense when their blood pressure is rising or when they're about to have a panic attack and will come in, are trained to come and do comforting, nudges or get pets so that they help them regulate. Yeah.
Rep Hoover.
So you mentioned certification. I'm under the impression that there really isn't a certification process for emotional support and possibly even service that's recognized.
That's correct. You can certainly get a lot of service animal training, and maybe at the end of that training, you will get a certificate, but you can also just go on the internet and buy a certificate pretty easily. And it's not necessarily a reliable means, and it's not required that someone have certification to be able to qualify as a service animal.
So you go to Amazon and buy I'm a service dog.
Jacket, leash.
Yeah. And so it's the more meaningful question is really, is it trained? What is it trained to do? Yeah. People love talking about assistance animals.
Yes.
It always happens.
Riveting Q&A. Yeah, no, totally.
I think this is one of the, and I feel bad for those who need the animals, because I think too many people have taken advantage of this service animal dialogue and come up with any excuse they can to put a leash and a jacket on their dog. I mean, you see little tiny Pomeranians or what, I mean, they're more of an emotional support dog. They're certainly not gonna tell you that there's open your cabinet door for you or, what some of the animals are. I think and it does a disadvantage to those who really need it. And it's too bad that people have taken advantage of that label.
It's very true. I think that because there's an association with people kind of scamming this system, that all people who have legitimate service animals kind of bear the stigma of that. And it really presents a lot of barriers for folks. I will say also those service animals don't always like physically help with things. Sometimes folks, for example, will have like a seizure disorder and they need an animal to be able to alert them to go get help with someone else, and things like that. So there's actually a broad range of services that these animals can provide for folks. And the many folks who have had complaints with our office, there has never been a question of the legitimacy of the animal.
There you go.
So I just want to build on something Rep. Hooper said. So anybody could go get a service animal vest and put it on their animal and claim that it's a service animal, and there's no procedure that violates.
No, the vest is also not required for service animals. So the vest is sometimes used, but not appropriate to require someone to have.
I agree with Rep. Pincinel that really takes away from the people who have participated in training with their animal, got certified, and have a real need for that animal. I've known people who need service animals before, and I think that kind of leads everybody to questioning all animals now, which is really a shame.
It is a shame. Yeah, I totally agree. And I've seen the effects that kind of stereotype will have on folks with disabilities. And we always look at it that for every service dog case we hear about, there's probably another 10 or 20 that we don't hear about. So I do believe that the folks that are, not being authentic about their need for a service dog are the exception and not the rule. Just like any right, there's going to be folks that kind of take advantage of the system at times.
It's like that 20-foot giant python that wraps. That is their service animal. It's like their comfort animal. Yeah, for the day I'm on an airplane and he comes in with that thing. This is.
Sounds comforting. I'm conscious of time.
Yes, thank you.
And I did have a few more slides I wanted to go through with you today. So this is an overview of our HRC cases. So in the last 2 years, the last 2 fiscal years, out of all of the complaints that we accepted for investigation, as you can see on this pie chart, well over half of them have involved disability discrimination. And then in the bar chart, you will see when we did find reasonable grounds to believe that discrimination occurred, how many of those cases involved disability. And it is a substantial portion of all of our cases and a substantial portion of our reasonable grounds cases. And then I have one more slide about our casework. And this is a snapshot of today, our current cases that we have open. About 60% of all of our current cases involve allegations of discrimination based on disability. So you can see the breakdown of how many cases we have that are under active investigation. And in blue, you'll see that 44 out of 69 of those are based on disability. The cases that have found reasonable grounds in the last 6 or so months are, we have 10 of those that are based on disability, and a smaller portion of them are in litigation, likely because they have settled. Okay, any questions about HRC data? And again, I'd be happy to come back in another time and give you some more breakdown of what our cases look like in the various areas of jurisdiction that we have. So I'm going to just briefly kind of breeze through a few slides from that relate to our Civil Rights Summit. And I'm going to come by later today and drop off the booklet that I meant to give you.
We actually have them electronically.
Beautiful.
So if you can't make the trip back, we're good with electronics and.
Great. Yeah, some committees really like the hard copy, so I always try to have them available. And the snow threw me off this morning, I think.
Don't make the special
I'm right down, so our office is right on Baldwin Street. It's halfway down the block here. I'll just say that in November, to address what we all feel is a federal civil rights crisis, we convened a 3-day civil rights conference in Randolph, where we had over 300 people participating, both to bring community members together and to strategize solutions for what we can do to ensure that we do have strengthening civil rights protections here under state and local law. We covered a range of issues, and I'm just going to highlight a little bit on the 2 panels that were discussing disability rights. When you scroll through the document itself, there are QR codes with active links that you can use to actually watch the panel discussions and hear from folks in the disability community and their advocates about the proposals they have for ensuring better access and overall disability justice. So I'm just going to give you a quick overview of the 4 recommendations that arose out of the panel, the 2 panels that we had about disability justice. We had a panel about voting access for people with disabilities, which I highly recommend you watch, that I moderated. And this was highlighting the voices of people with disabilities who have actually been actively denied the ability to participate in their state and local elections because of their disabilities. We actually rank as one of the worst states in the entire country for accessibility of our voting, and that mostly is going to our local elections. So individuals with disabilities are actually routinely and systematically denied access to their local elections and their town meetings when only in-person participation is permitted. So there are folks who do not have the ability to physically attend town meeting and are routinely denied reasonable accommodations to be able to participate in those meetings or even watch them remotely. And when they do get those accommodations, their disability is then made public to their entire town. So we are encouraging in the voting rights bills that are currently being considered. I think they're on the Senate side right now. We do encourage some additional provisions to ensure equal access for folks with disabilities. And in some ways that will mean prioritizing resources to towns so that they are able to provide the reasonable accommodations within their means. But in many cases, advocates are calling for Australian ballot in all local elections. And without that, there is not a way for folks who are remote to participate in their local election. And so the first 2, I'm sorry, did you have a question?
Yeah, I did. What do you mean that their disability is exposed to the entire community?
So a few different things that I've heard reports of. I've heard reports of local select boards discussing somebody's disability related request in open session, so that the person's name and their disability is then discussed in the public and it is in the minutes. Also, if they are the only person who is allowed remote access, then they're essentially outed to their community as the one person who needed remote access.
How would the public know that they got remote access?
In town meetings, they will be visible. In virtual meetings.
I would, yeah, I guess I could see that, unless just their phone number or some pseudonym is on the screen, like their real name isn't on the screen, but it's known to the moderator who's letting them in. That could be a way around that. I'm just thinking through this. Also, the select board should know better to not discuss somebody's personal health information on the record. But
I encourage you to hear the stories from the disability community directly, some of which are highlighted in that panel discussion about voting access.
thank you.
And I know that they would be happy to provide some testimony if you'd like to hear it.
Rep. Hooper.
So the changes that were made in open meeting, executive session sort of include this or exclude discussions in executive session or off the public view for at least.
Yeah, executive session is supposed to be out of public view. The stories that I have heard is that they chose not to go into executive session to discuss those reasonable accommodation requests that were made to them.
So in the new statute, it's one of the allowed items to do with executive sessions.
And I'm not sure about that, but I'll take your word
Yeah,
for
I
it.
don't remember that being specifically included.
The instances I'm aware of occurred in the last year and are part of a longer pattern of voters trying to be able to vote and not being able to because of their disabilities.
I just came in late.
Hi, that's okay.
Parenting duties, but
Yeah.
I didn't know if you had talked about the Secretary of State's working groups that she's created. I'm on one about improving accessibility for folks who are differently abled. And we've had some really robust and
Mhm.
great conversations, and we'll be bringing that information, I'm pretty sure, to this committee soon. But yeah, we're hearing a lot. The physical access, it's what lack thereof is what led me to be on the working group. Because yeah, a lot of our places where people go to vote, I don't know who did, who surveyed them back in 1800s or whatever, but a lot of them are not ADA compliant, even though they're listed as such. And I know that as an OT who's been at the polls myself and thought there's no way people in a wheelchair could access some of the ones even in Burlington. I've had to help people up sidewalks that are not ADA compliant. So I don't know if you knew those working groups were happening, but they are.
Absolutely. HRC had a designee on the Act 133 working group. We've been actively involved with those conversations and be happy to talk more about that working group process anytime.
A lot of stories are coming out of it, though, that would be
Yeah.
helpful for folks to hear.
Yeah, we did select a designee who was a person with lived experience who had been denied the ability to vote in their town. And so that was really a voice that we really wanted to highlight. Thank you. I'll just quickly, I don't want to go over time too much more here. There was another panel about the Olmstead Commission. Olmstead refers to a U.S. Supreme Court decision from 1999 that declared that unjustified segregation of individuals with disabilities violated the ADA. In response to that, many states created an Olmstead Commission to systematically assess their state and how we were going about preventing unnecessary institutionalization of people with disabilities. Our state plan has not been updated in 20 years, and the incarceration of people with disabilities has just gone up and up since then. So the disability community is strongly urging lawmakers to create a permanent Olmstead Commission that would be able to study and report on that issue. And then there's also a concern about in-home care providers for folks with disabilities who are able to stay in their homes and in their communities because of in-home care only. In-home care providers are not earning a livable wage, and it is making the stock of folks who can do that work limited. And it's not a sustainable model for ensuring long-term in-home care. So I believe there is a House bill about this that would ensure a livable wage for in-home care providers. So those are the 4 recommendations that came out of the summit. Again, I encourage you to hear from the voices of the disability community who have been working on these issues for decades and are both having much more expertise than me and also have that lived experience that is really valuable to hear from.
Any questions? No, thank you so much for the time.
I'm sorry for going over, and I'd be happy to come back again anytime.
Okay. No, thank you very much. All right, folks. So up next, we have H93, an act relating to the creation and maintenance of a database for veterans in Vermont. This is a reintroduction and walkthrough. This is something that was put in by Representative Hoover of Burlington. And we have council here with us. This is sort of a refresher as we're working on the broader Military and Veterans Affairs bill. Just to get the subject matter, content, purpose back in front of us. Good morning, council.
Good morning, Sophie Zadatny for the Office of Legislative Counsel. Happy to be here again. And I'm just gonna, is it okay if I go ahead and share my screen?
Absolutely.
Yes, as the chair noted, this was a bill that was introduced last session. And it comes from, it reruns a portion of H-168, which was an act that was passed in 2023, but it didn't pass. And this simply requires the development and maintenance of a database of veterans residing in, and it would create a new chapter for veterans within Title 20. And it provides, go through this. This would be a new chapter. It would provide that the director of the Vermont Office of Veterans Affairs would work with other agencies, offices, and departments to develop and maintain a database of veterans in Vermont. All the agencies, offices, and departments shall, to the extent practicable and consistent with state and federal law, provide information on veterans in Vermont to the director of the Vermont Office of Veterans Affairs. Any personally identifying information about veterans collected for the database would be exempt from public inspection and copying under the Public Records Act. And then it has the, that particular exemption would not be repealed. So that's it in a nutshell. It's a short bill. There was testimony last session on the bill, and I know that the Robert Burke, the director of the Office of Veteran Affairs, did come in and testify in March about the bill. He did raise some concerns in terms of, how the data would be collected, how it would be maintained, the need for, IT support, software, et cetera, to manage it. So that was just what I recall from his testimony last year. But that's the bill.
Senator Pango, then Representative Nugent.
Thank you very much, Sophie, for bringing this back up. I had not remembered fully the testimony, but this is bringing it back to me. So what would you say that from that testimony that the biggest concern was IT support for this? It was not some other issues?
It was the resources, like additional resources would be needed. I think human resources as well as IT, software, hardware resources.
Thank you so much.
Representative Nugent.
As far as the data that is not accessible to the public, would it be accessible, or what entities in the government would it be accessible to, and could it potentially be sold at any point, or is that covered in this bill?
It's not explicitly covered. I think the goal would just be that somebody couldn't request it, to do a data scrape on it. I think the goal would be, and again, Representative Hoop is right here to talk about the goals behind the bill. But my understanding was it was a way, other states have these kinds of bills, these registries. And the goal is for those bills is to share information, resources, with the veteran community. So it's a way to make sure that, the states are reaching out to all the veterans in their state, and the veterans have all the information that they need about what services are available.
Is it voluntary? I didn't catch.
In some states it is. There is language that they can opt into a database. There isn't anything specific in this bill draft on that.
Representative Pango.
Thank you. You mentioned other states. Do you happen to know any of the other states that have the registry? We can also look it up.
Yes, so I looked at Indiana, Oklahoma, Pennsylvania, but there are a list of other, and I will admit, this was an AI quick search, that said several states have established veterans registries to track, honor, or connect veterans with services, including California, Connecticut, Florida, Indiana, Kentucky, Oregon, Virginia, Alaska, Arizona, Delaware, Georgia, Idaho, Illinois, Iowa, Kansas, Louisiana, and Maine. And then, I looked specifically at the ones in Indiana, Oklahoma, and Pennsylvania.
Thank you very much.
Yes.
Do either of you, Rep. Hooper or Sophie, want to speak to the reason behind this bill, why it came to us? I know it, but maybe the public would like to know the kind of the backstory, because this is not the first biennium that this bill has been introduced. It's been several biennium. And I think it has to do with being able to locate veterans after they separate from the service. Is that correct?
Say the last part again, please.
I believe the intent or the reason behind the bill was to locate veterans after they separate from the service, because there is no record of them past that point. Is that correct?
It's kind of complicated. People who ETS and either have a residence in Vermont or coming to Vermont, their DT 214 sent to the state office. People who come into Vermont who got out of the service in different jurisdictions, their line 214 was in Pennsylvania. They have it transferred up there. So there is the genesis of this request came from the Governor's Veterans Advisory Council. I have yet to hear back from the governor's office whether he actually has his stamp on it or not, but the most common reference to the necessity is like the burn pit legislation that we passed, that passed by word of mouth, passed by American Legion, but there was no mechanism for the state of Vermont to actually let resident veterans know that this benefit or this concern was available. So it's a tool for notification as well as having accurate records of how many veterans we have, what their status is. Right.
I would just add that from the research I did, my sense was that a lot of the other states that have registries, it actually did come about in connection to the burn pit issue, because just the timing of when those statutes were passed, like around 2019.
Now, even now, a lot of the VA has changed its determination practice for Vietnam, Korea, people who were exposed to Agent Orange. They've really revised accessibility, disability for that. Who knows?
And I would add too that very recently, I believe it was Kosovo, was added to the countries that the pact covered. So there are veterans out there who may not know that, who served in those areas, who are not part of any registry and can't be reached. If they happen to be in communication with their VFW or their American Legion or their Disabled American Vets organization, they might learn about that. But unless they read the news when it came out, they may not know that their medical conditions are covered at this point.
I think the problem that we had with this back in March of last year was that Bob came in and looked at the administrative burden of how do you get the paper to me? What do I do with the paper? I need another person. I've been in touch with IT and they're doing stuff now that I think would make this a lot easier, electronic processing and disseminating the information. Bob still may need a half position to deal with that. But quite frankly, that office needs more people, period, because you wait a long time to get service from them.
Yes, Rep.
I believe the federal government has this database. And the reason I say that is because when Danny was diagnosed and they told us to make sure we got into the burn pit registry and one other registry, which just slipped my mind at the time. But as soon as I put in his social security number, in every place he'd ever been where he could have been exposed to toxins was listed. And all of the other things that he could have been exposed to. So it's like they got it. So like my argument was at the time was, why aren't they going through their database and contacting all these military soldiers and saying, look, you've been exposed, you need to get on this registry, or you need to. It was mind boggling.
Is that DOD or VA?
I believe it was VA, it might have been DOD, I don't know, but it was just amazing, all the different things that came up that, yeah, so like they've got the database, so why aren't they,
We should include language that they have the ability to go to the feds. and-
but anyways, that's fine. They know.
Hold this.
Well, I can remember from years ago having this conversation right after the PACT Act. And during that time of the burn pit registry being established, that it's quite complicated. And so we will need to hear from all those witnesses again to find out what the story really is.
Well, I just said I think we should amend the bill to include authority for the local office to tap into whatever federal resources are available.
It doesn't, the current language isn't limited to state offices. I mean, it says the director of the Vermont Offices of Veterans Affairs shall work with other agencies, offices and departments to develop and maintain a database. And then in the next sentence, it says shall to the maximum extent practicable and consistent with state and federal law provide information on veterans in Vermont. So it's not, it wouldn't preclude, the way it's written right now, wouldn't preclude obtaining information from the federal government.
Another minds.
Yes.
I'm just gonna take it one step further. Up until Vietnam, the state of Vermont used to put out a book that told of every Vermonter who served in that period of time. Like there's a Korean, there's a World War I, a World War II, Korean, there's even the American Revolution. And it lists all of the Vermonters that served in it. It's their in alphabetical order by their last name, first name, their rank, and their hometown and their rank. And then if they did foreign service, it would tell foreign service and what's the word I'm looking for, guys?
Branch?
No, theater, that's the word, what theater they served in, whether it be an Asian American, Asian, whatever, Pacific, whatever. So, but after Vietnam, they stopped doing that. And I mean, now since then, we've got the Gulf War, we've got the Iraq, so.
Freedom.
Racial freedom, yeah, so I don't know who, I believe they were put out by the, I don't believe they were put out by the veterans of, the VA or the Department of Veterans Affairs. I think it was put out by the Secretary of State's office, or, I mean, I could look in the town clerk's office, but town clerks have all those books. Vietnam is the last one they published,
Did not put the crap to a lot of
yeah,
information behind.
but they're a great resource.
We have any other questions for Rep. Cooper or council right now on this? So, and apologies, I'm a little foggy this morning. I'm feeling a little under the weather. My brain's moving a little slow. So it has the ability to coordinate already drafted, correct? Then I guess my question is, we're doing one more bill. But we're doing one more bill right now with the Gold Star, and I want to be cautious of time, so I definitely want to flag this for consideration thoughts bill. To talk about possibly including that next time we talk about what we're going to include further with that. So If everybody's, excuse me, if everybody's cool with it, we'll flag this for a conversation. Sound good? Lars?
Yep.
Wonderful. Sorry, that was a lot of words to get to a small point. All right. All right, and next, horribly behind. Up next, we are doing an introduction, walkthrough, and witness testimony on H 884, an act relating to the definition of Gold Star family members. So yeah, Rep. Stone, please.
Good morning, everyone. Thanks for the opportunity to speak about H 884, an act relating to the definition of Gold Star family members. For the record, Mary Catherine Stone, Chin 14. This bill, which has bipartisan support, seeks to fill a gap in Vermont law by establishing a clear statutory definition of who qualifies as a Gold Star family member. Right now, Vermont statutes use terms like Gold Star family in contexts such as license plates and recognition programs, but there isn't an explicit legal definition in the statute books. That absence can lead to inconsistent interpretation, confusion for families seeking recognition or benefits, and potential barriers when other laws or programs reference this status. This bill proposes to ensure that when state policy refers to, quote, Gold Star family members, end quote, there is a shared, clear understanding of what it means. Under this bill, a Gold Star family member would be defined to include those who have lost a loved one who died in service of the U.S. Armed Forces or as a result of a service-connected injury or illness. Example, burn pits, Agent Orange, those kind of things. By codifying this definition in statute, we're not changing eligibility for any specific benefit today, but we're laying the groundwork so that future laws, benefits, recognition programs, or supports that refer to Gold Star families are grounded in consistent and respectful language. Language matters when families who have paid the ultimate price for a country seek recognition, benefits, or even just clarity about their status. They deserve a clear statutory foundation that does not require administrative guesswork or subjective interpretation. By defining the term in statute, we honor their sacrifice with greater certainty and help ensure that state policies intended to support them do what they are meant to do. In short, this bill is a foundational housekeeping bill. That's the way I see it, ensuring that our state operates with consistency and respect for families who have endured profound loss. And before people ask about, is there a federal definition we could use? There is not a single uniform federal legal definition of Gold Star family. Federal law and practice recognize and honor these families in many contexts, but the statutes don't define the term consistently. And that's why this bill is needed, in my opinion, because it would give Vermont clear, inclusive statutory definition so that state law can treat families equitably and without ambiguity. So just housekeeping. This is an oopsie daisies, in my opinion. It should have lived in statute the get-go, but it didn't. And that's what this is trying to do to clean things up.
Rep. Hoover has anything?
What's the DMV criteria to get a license plate?
That's another question. We're another bill that we talked about that's very different than this. As far as Gold Star, I feel ill-equipped to tell you, but maybe Sophie could, but
Okay.
yes.
Flag that for council. Anything else for Rep. Stone?
And then Ms. Heston's behind me on the screen.
Good to see you, Joan. How are you?
I'm good, thank you. How are you?
Good. No, thank you for your patience. We did run a little over time, but it's really great to see you come in again.
Thank you. It's my pleasure.
Yeah, the table is yours.
Thank you so much. Thank you for the opportunity to speak to you today relating to H 884 regarding the definition of Gold Star families. As you know, my name is June Heston. I'm the surviving spouse of Brigadier General Mike Heston. Mike passed away in 2018 as a result of service-connected illness due to exposure to toxins from the burn pits while he was deployed to Afghanistan 3 times between 2003 and 2012. shortly after Mike passed away, I was contacted by a staff member at TAPS, the Tragedy Assistance Program for Survivors. This organization serves all military survivors regardless of their cause of death. The resources they've provided helped me with my grief, my children's grief, survivor benefit questions the resources were immensely impactful. And I'm not sure where I would be here today if I wasn't made aware of that organization. I depended on TAPS to provide the guidance, the support, and understanding ear when I needed it. Since then, I've become much more involved with TAPS on the policy level. What you have in front of you is the Gold Star Family Compact that lists 5 key priorities to ensure our military survivors are treated with respect, dignity, and recognition for their loss. In 2024, I presented the compact to the Governor's Veterans Advisory Council, where they voted to accept this as a priority to move forward. I also met with the Adjutant General, Major General Greg Knight, who was also in favor of the compact. And I met with Governor Scott, who was in agreement that this compact would make sense to support. Since then, TAPS has continued to present this compact to the National Association of State Directors of Veterans Affairs with the objective of getting states to sign on to this compact. The 2nd through 5th key issues already have federal legislation introduced that TAPS is working on. This one issue has not had federal legislation introduced yet. So we're here today to discuss the first issue on the compact, adopt a respectful and inclusive definition of Gold Star. The U.S. Department of Veterans Affairs doesn't distinguish by cause of death. There's no differentiation of government benefits to survivors based on the location or circumstances of a service member's death. In contrast, the state and territory definitions of Gold Star are more narrow in scope, with some only including those killed in combat. This disparity, as Representative Stone spoke about, causes survivors to face barriers to state and territory benefits and assistance. Now, in Vermont, for Gold Star family recognition, it's only for the Gold Star plate itself. Vermont follows the federal definition found in U.S. Code, meaning if the service member died as a result of service in war hostilities recognized under 10 U.S.C. subcode 1126A, the family qualifies for Gold Star family. Next of kin plates, which is sort of the next level, has a broader state recognition. Vermont also has next of kin plates separate from the Gold Star plates, and these are available for family members of service members who died while serving on active duty for training, or assigned to a reserve or National Guard unit in drill status, or they died as a result of injury or illness incurred during such service or assignment. This second part is important. Vermont's law explicitly provides a category for death resulting from injury or illness incurred during service or assignment, even if that death is not covered under the stricter federal 10 U.S.C. subcode 1126A war or non-combat operation definition. If you're wondering why this is important, I will give you an example. I was struggling to with finding an answer regarding a benefit or some of the benefits shortly after Mike's death. And I called our family readiness office and spoke with the survivor outreach service employee, who I knew personally. When I asked if she could help me, her exact words to me were, "Nope, you're not Gold Star." So if you just felt an emotional reaction to what I just said, multiply that by 100. And that's how I felt. Why is my loss less than? TAPS encourages the adoption of a respectful, inclusive definition of Gold Star that encompasses all service-related deaths with the phrase, died while serving or from a service-connected injury or illness. As states sign on to this compact and adopt a more inclusive definition for Gold Star, TAPS will gain leverage in their work on introducing a federal definition, legislation for a federal definition that's inclusive. Today's warfighter often brings the battlefield home with them. Families and survivors are most often the ones that continue to pay a price for that service of their loved one. Vermont's often been at the forefront of legislation that addresses respect, dignity, and recognition of others. And I urge Vermont to be a leader in this effort. Thank you very much. Thank you to Representative Stone and all the reps that signed on to this bill. And if you have questions, let me know.
You have questions for June? Star.
I put a lot of legislation forward, and a lot of it focuses on supporting veterans and their family, because I don't think that we can ever do enough, but this is one of the most important bills that I've had the privilege of sponsoring. If this is a bill that passed out of this committee, I would be happy. That's all I can say.
Thank you. Thanks for bringing this forward. I just want to note for people who are watching that just because reps didn't get a chance to sign on to bills doesn't mean that we don't support them. So I want to make that really clear, because I've had some people approach me about, like, why aren't you on this bill, or why am I not on this bill? So there are so many bills out there that we don't always get the opportunity to sign on to all of them. So yeah, very supportive of this. And I'm really happy that Rep. Stone brought this to our attention.
Any other questions or comment right now before I move over to council? Yes, Rep. Waters.
I just wanted to say thank you so much. It's difficult testimony to give, and thank you to others maybe in this room who've been affected by it. It's really important that you're doing this and helping others, even though you have, been in pain. Thank you.
Thank you.
All right, no, thank you very much, June. Please feel free to stay with us for the rest of the conversation with council if you like. Council, thank you.
Sign off because I'm on vacation in Florida.
Oh, okay. I was looking at the backdrop. We've done enough Zoom time. I'm like, where is she? That's unfamiliar. That makes more sense. All right, enjoy
you
your
very
trip,
much.
June. Yeah.
Thank you. Bye-bye.
Sophie Zadani again for the Office of Legislative Counsel. And is it okay if I go ahead and share my screen?
Yes, please.
As discussed, this is currently just a short form. And what's being proposed is to add a definition of Gold Star family members into, at the very beginning of the Vermont statutes, there's a definition section along with how you can, construction of statutes. So the proposal would be to place this definition in there. And so that's really simply what this is seeking to do. I did have a question around the definition. So there was mention just a short while ago about the license plates. So this is under 23, section 304, K1, and it provides Gold Star plate shall be issued to the widow or widower, parents, and next of kin as defined in 10 USC 1126D, who lost their lives under the circumstances described, and that's in the federal statute. And then the next of kin plate is under B. So I did go to look to see what that definition is, and under the statute 10 USC 1126, it doesn't really tell you exactly what the definition is, but it refers you to a Department of Defense definition. So this is what the current definition is. So again, it's the Gold Star. This is talking about a lapel button, but it's where the definitions are. So again, it's a service member who lost his or her life, and then it lists out the different situations. And then eligible next of kin. So I had a couple of questions if this moves forward, is whether or not we want to spell out, like when it's Gold Star family, if it's Gold Star, like the definition of a parent or a child, because it's quite an expansive one here. For example, I looked at the Massachusetts law. So under Massachusetts, they say she'll mean any parent of a member. And I thought, well, that's odd. Don't you just have two parents? But no, it's an expansive definition because it covers step parents and parents-in-law and whatever. It's by adoption. So it's quite expansive. So that was just one question I had for the committee to think about. And then the other one was if the General Assembly adopts a Gold Star definition as recommended, really be again around died while serving or from a service-connected illness or injury. I think the committee would also need to look at whether to change the license plate language, because right now you would then end up with two inconsistent definitions under state law, because you would have one that's referring to federal definitions, and then you would have the state definition separately.
Meaning it'd probably be another bill, right? Because it would be something that needs to go through transportation. Is that what I'm understanding? Just that's like when you asked, I'm thinking that the license plate would be a different. It'd be a little tricky.
Yeah, I guess it comes out of of any of the founders.
No, that would definitely be something transportation would have to address directly, but we're having that other conversation about one of those bills too,
Right.
so that could possibly be bundled into that conversation.
a
to address
different-
both things, yes, because you have those two points of contact to make sure that there's like consistency and clarity of the definition.
Right.
You might have two vehicles doing it, or maybe one speaks to it with like here with a crop reference and they just,
But it needs to have its own little car, its own vehicle.
no pun intended, yeah. Yeah.
Yes.
For the license.
I don't know if the pun was intended or not, I'm slow to the punch today. But yeah, but we're already having conversations with the transportation committee, so this is
About
something to try and figure
Yeah,
out.
just,
I just wanted to clarify, because if you've got a state definition at the beginning that says this is how Gold Star is going to be interpreted, and then you've got a reference under the
right. I
transport
get what you're
statute.
saying, just clarifying that we'll probably need two bills to handle all of it.
Okay. That's what we do here.
Yeah. I was gonna say it.
Right? So, yeah, no, I mean, the mirrored language is obviously important. So, and the continuity is very important. So any other questions on this piece right now? Seeing no hands, all right. And that puts us shockingly on time all of a sudden. We made up clock. So we're back to the conversation with H 811, an act relating to the election of the Adjutant General and Inspector General of the Vermont National Guard. And so let's go back into this one.
Did you want me to put that back up?
The 881?
Yeah.
Yeah, if you could. We got it on our committee page, but that would help. Yeah, and this is back to sort of the conversations about continuity in statute, right? So this is very much a similar conversation, if not the same. And
I don't want to throw a wrench in this, but I'm going to. I've had a lot of people ask me about the Inspector General and why we're nominating the Adjutant General and Inspector General, and I did some research. And the Inspector General within the Vermont National Guard, there's a federal Inspector General within the Vermont National Guard, which is its own position underneath the Adjutant General. So to me, I think that perhaps we should entertain the idea of changing the language to the fact that we are just electing the Adjutant General and not the Adjutant and Inspector General. It has been communicated that they are the same thing. They're not. It's a different position. It's like pretending like Lauren Hibbert and Sarah Copeland Hansis are the same person because they work in the same department. They're not. They have two different jobs. And that's the same with the Inspector General and the Adjutant General. They're not the same.
yeah, we years ago had to have conversations around the Inspector General position. That was, I mean, this was maybe a pre-COVID conversation. I was going back that far, where it did delineate the two. And then as far as, yeah, I mean, the question within how it's like referenced in statute, which you making it look like it's interwoven, right? Yeah.
It's not.
I guess I defer to counsel on that.
I
Yeah.
did. Sorry, it was late last night, but I did take a look at that and then this morning. So I don't think there would be any reason not to clarify that it's the Adjutant General and just take the Inspector General out from the title. My understanding is, again, it's a historical, thing, that what happened originally was that the Adjutant General was also the Inspector General, and so these two positions were combined. But unless there's some sense from the National Guard that that's a problem to take it out, I didn't see any other concern on changing it, because again, these are two separate positions at this point, so it just seems like a historical.
Yeah, it's kind of a relic that had never really got tightened up. I got Rep. Hango, then I got Rep. Waters Evans.
So I think when we did the modernization, we did a really big housekeeping bill, the modernization of the Adjutant General in 2023, I believe. Barbara Murphy presented it on the floor, and it was really long and involved, and there were so many references that needed to be changed. This might be something that was overlooked in that change or somehow didn't get discussed, although I thought there was a really thorough discussion of it.
Yeah, so I looked at that this morning. So it was Act 10 in 2021.
2021.
Was it 2021, Sophie? I'm sorry.
2021,
It wasn't when I was here. I
Yeah.
started in 2023.
that was biennium 2 for our legislative class, Rep. Hango. And that was,
Yes, so Rep. Murphy was in our committee.
Correct.
Yes, so
Yes.
then my
but that, yeah,
apologies.
that
while
timeline
here.
sounds about right, based on the COVID math.
It used to be like Adjutant and Inspector General and Quartermaster General, and it did take out the Quartermaster
That's
General.
right.
So I don't know, and Damian Leonard was the legislative counsel on it, and he was looped into the conversation yesterday, and he didn't recall sort of why it still was Adjutant and Inspector General. So unless someone else has a recollection as to why that happened.
Did you have a follow-up? 'Cause
I do,
Yeah.
but Rep.
No, go ahead. If it's a follow-up on the previous. we might
Yeah,
as well
so was
stick with it.
mine.
Oh, I was just going to ask, when the last time is that we had one, if anybody knows, like an Inspector General and an Adjutant General, like two separate people doing those jobs.
Right now.
Like right now, that's how they do it.
Yeah.
There are two people doing two different jobs.
Yes.
Who is the Inspector General?
I don't have their name. Sorry, I'm just speaking out of turn, but it's because the guard brought it up and they had heard that people were saying, oh, it's the same thing. And the guard brought it up to me and said, fun fact, it's not. There is someone on base right now holding a federal position, and it's actually considered a conflict of interest because of the role of the Inspector General. You would not want the Adjutant General
Correct.
performing the position because they investigate.
It's an oversight position. That's,
It's a totally different job. It operates under federal orders. It is completely different. So to me, this raises a transparency issue with what people are voting on. Because like I said, it is like pretending like Lauren Hibbert and Sarah Copeland Hance that they're the same person. They're not. They do two different things.
I thought it was two
Different roles, two different
roles for one
Two
person.
different roles, two
Well,
different sets of orders, and one is an oversight
it
position.
was historically.
But not now.
That's what we're saying, where it seems to evolve to a different structure, or it has evolved to a structure with this is language, as I refer to it, as a relic. And this came up, if I remember correctly, within the context of a conversation in and around like on base and off base policing and continuity or lack of continuity between like those entities at the like military level and the community. So that was just a little context as to what I recall this conversation being years ago. But yes, so it seems they are separate.
Yeah, so right now there's someone called Jonathan Elias is the Inspector General currently. And based on the email from someone over at the National Guard or Military Department yesterday, it sounds like that's a federal position, not a state position. So again, I think the title is just an old title, but the duties are separated at this point.
I feel like we need to fix that.
Well, it's kind of brought it up.
Totally right there. Yes. No, and that's the thing is like we're using this, this is why I like doing these like sort of omnibus bills with the subject matter. So when we can find things like this, we have a relevant vehicle for what's presumably a smaller conversation, but a necessary conversation. Rep. Hanger, still have a hand?
Yeah, I just wanted to make sure because I wanted to confer with the House Clerk because when we held caucus of the whole, she repeatedly used the term adjutant and inspector general. And I questioned her after, and she said that's what the statute says. So I just want to make sure we cover all of our bases, but my recollection of the presentation on the floor for the modernization of the National Guard Adjutant General was the removal of the Quartermaster General. It wasn't the Inspector General, so thank you.
Yes, I believe this selection would be for an adjutant and inspector general because that is the current title. So any change you make would be for, the next election.
Right. I have Rep. Stone, then Rep. Evans.
I'm just gonna say, I recognize what it says in statute. I also recognize that our House Clerk doesn't work for the Department of War. I'm just saying, like, the Inspector General is a federal position, and I know there are things that live in statute that are not always correct, and this is one of those things. So I recognize that our clerk may be referring to statute, but it doesn't mean that their statute is correct and reflects what is happening at the Guard base. For the people who are holding positions at the Guard base, that's what's happening, boots on the ground, is that there's somebody who holds a federal position, it's the Inspector General, whose job duties are very different than the Adjutant General. So when we go in to vote, we are not voting on, I already forgot this person's name, Inspector General.
Jonathan.
We're not voting on Jonathan, his name's not on the ballot, so it just feels disingenuous. To carry on.
Yeah, Mars Evans and Hango.
Okay. I just want to, now I'm getting, so it says in statute, the title of a general knight who has that job right now is, his official title is adjutant and inspector general.
Right.
Okay, so there's an inspector general and there's an adjutant and inspector general, right? Those are two different titles.
Right.
Okay, all right. That helps me a little bit. I don't think it's urgent right now, but I was actually confused about it as well. So maybe for the next time around, we can take out that inspector part. But right now, maybe just clarify for everybody in the body that that adjutant and inspector is those are two adjectives modifying the word general, right?
It's one person, but that their official title includes inspector general, even though they are not the current inspector general.
All comes down to parts of speech, adjutant and inspector as opposed to inspector. Those are two different titles. Okay.
Yeah.
Sorry, I got a little mixed up for a second, but now I get it. Thank you. Just wanted to-
Yeah, no,
Okay.
it's like as far as like the charges and duties within the actual execution of the role itself, they seem bifurcated that the language that exists with the and it's the saying it's just a sort of a relic of time past which was the role. Yes, Rep. Evans, I got Hango, I got you.
Sorry, just a follow-up here. So then if we are talking about this particular bill, I wonder if this is something we need to address in the future, and would it be, I guess, if then we would have to make a change again to this next time around or whenever we introduce the language to change it, because right now it would have to remain adjutant and inspector because it's what it already exists in statute. Right?
This election, yes.
Okay.
Selection.
Okay.
I mean, just make sure everyone understands that it's one person doing one position and part of the title someone else is doing, but
Okay.
they're not doing
So
both.
next year to bring it back as a housekeeping.
No, I mean, I think we do it now.
Let's
Do it now. Vehicle, we got it in front of us.
And I
say
just
do it
like
now.
it.
It's just not gonna impact the language for the title until it goes into law.
Gotcha.
Yes.
So the election stays the same, it's just this week.
All right, Hango Nugent.
I just wanted to go back to my conversation with the House Clerk. I think it's just a misnomer of the position. I wasn't suggesting that it was anything other than that. So I'm great with the change as long as it doesn't affect the upcoming elections at all process. 'Cause I'm sure the ballots are being printed now. So just wanted to cover all bases.
That was similar. I think my question's answered. Just wondering what this, you know, the stakes are if it's not by the time that we get the health election.
I guess it's been this way for some time.
Yeah, because we dropped the quartermaster last time and it didn't really have any impact on the function within the inspector general. In his federal position being separate from the adjutant general themselves. So, you know, and this is just the stuff that when you mine into this stuff, you start finding, I mean, we're an old state, you got a lot of old statute. And you find some old things sometimes and you're like, wow, that's still here. Yes.
I'm just saying, I just learned about this recently, so I'm not saying it's malicious intent or somebody's trying to hide. It's just like, I mean, we don't work on the guard base. We don't have an inspector general bebopping around here. So I'm not saying that anyone is like, you know, doing a bad job. It was an honest mistake. I just uncovered it this week and I let the cat out of the bag. So
Okay.
thanks.
Good job.
Yeah.
So I have a question in terms of, so this is a short form bill. Do you want me to go ahead and turn that into a standard form bill and then include this change as well? I mean, I don't know how you,
The conversation we're having right now. Yeah. Let's see the
Yeah.
long form language, please.
Or inclusion with
Yes.
other.
Yes. So I've got
omnibus.
yes, correct. So right now I have continued work on it 93.
Yep.
I have continued work and inclusion on Gold Star. And continued work and inclusion on the Inspector General.
okay, so do you want me to do one bill with all those in it?
But can we look at the language separately and then we're gonna like
Okay,
put them into the larger one that we're working on?
okay.
That would be helpful.
Make sure I'm giving you what you're looking for.
I so appreciate the
Thank
clarifying
you.
question. All right, committee, let's, before we go into this next slug of work, I want to call a 5-minute, 7-minute, let's call it, go off until 10:40. And we'll pick up work on 588, our OPR bill.
How are you?